Like and subscribe to support the channel. Donations welcome.
Understanding the intricacies of contracts and agreements is paramount for protecting your financial rights as a consumer. Many consumer finance transactions, from credit card agreements to loan documents, involve legally binding contracts. A thorough understanding of contract law can empower you to navigate these agreements effectively and avoid potential pitfalls. This section will demystify key aspects of contract law, enabling you to better protect yourself in financial dealings. At the heart of any contract lies the fundamental principle of mutual agreement. This involves an offer made by one party and an acceptance of that offer by another. An offer is a clear and unequivocal expression of willingness to enter into a contract on specific terms. It must be sufficiently definite to allow for a clear understanding of the obligations involved. For instance, an offer to loan money must specify the amount, interest rate, repayment terms, and any other relevant conditions. A vague or ambiguous statement does not constitute a valid offer. Similarly, an advertisement offering a product at a specific price is generally considered an invitation to treat rather than a formal offer, meaning it's an invitation for customers to make an offer to purchase. The seller is then free to accept or reject that offer. Acceptance, the second crucial component, signifies the unqualified assent to the terms of the offer. It must mirror the offer exactly. Any alterations or modifications constitute a counteroffer, effectively rejecting the original offer and proposing a new one. Acceptance can be communicated orally, in writing, or through conduct, depending on the nature of the agreement. However, the method of acceptance must be in accordance with any specifications stated within the original offer. For instance, if an offer stipulates that acceptance must be in writing, an oral acceptance may not be valid. Silence, in most cases, does not constitute acceptance. A contract is not formed simply because someone has failed to respond to an offer. Active acceptance is required. The third essential element of a valid contract is consideration. Consideration is something of value exchanged between the parties to the contract. It can be money, goods, services, a promise to act, or a promise to refrain from acting. Consideration ensures that the agreement is not merely a gratuitous promise, but a reciprocal exchange. Each party must provide something of value to the other. For example, in a loan agreement, the lender provides money, consideration, and the borrower promises to repay the loan with interest, consideration. The absence of mutual consideration renders the contract unenforceable. There are some exceptions, such as promissory estoppel, where a promise is legally binding even without formal consideration, but this applies in specific situations. Once a contract is formed, it creates legally binding obligations on both parties. A breach of contract occurs when one party fails to fulfill their contractual obligations without lawful excuse. The consequences of a breach of contract can vary depending on the specifics of the agreement and the severity of the breach. The non-breaching party may be entitled to various remedies, including monetary damages, specific performance, forcing the breaching party to fulfill their obligations, or rescission, canceling the contract. The remedies available to the injured party are often linked to the type and extent of the breach. For example, in a situation where a consumer purchases a defective product under a warranty, they may be entitled to a repair, replacement, or refund depending on the terms of the warranty and the relevant laws. Similarly, a breach of a loan agreement might lead to legal action by the lender to recover the outstanding amount, along with interest and penalties. In cases involving fraudulent misrepresentation or duress, the contract may be deemed voidable at the option of the wronged party. Before signing any contract, carefully review its terms and conditions. Pay close attention to details such as interest rates, fees, penalties for late payment, and any clauses that limit liability. If anything is unclear, seek clarification from the other party or consult with a legal professional before committing to the agreement. Do not be pressured into signing a contract you do not fully understand. Take your time to read the fine print and ask questions. Understand the implications of each clause before signing. Consider consulting with a financial advisor before entering into significant financial agreements. A financial advisor can help you assess the potential risks and benefits ensuring the contract aligns with your financial goals and circumstances. They can provide unbiased advice and help you understand the implications of various terms and conditions. This is especially vital when making large purchases or obtaining loans with complex repayment schedules. Real-world scenarios highlight the importance of understanding contracts. Imagine a situation where a consumer signs a loan agreement without reading the fine print. Later, they discover hidden fees or penalties, significantly increasing the cost of the loan. Without understanding the contract, they might find themselves facing financial hardship due to unexpected costs. Alternatively, imagine a consumer buying a used car and failing to obtain a clear understanding of the terms of the warranty. When the car breaks down shortly afterward, they may be unable to make a successful claim for repair or replacement. The law surrounding contracts is complex, with specific details and interpretations varying according to jurisdiction and the specifics of each agreement. State and federal laws play a crucial role in defining the legal frameworks for contracts. The Uniform Commercial Code, UCC, for example, governs commercial transactions in many states, offering a standardized approach to certain aspects of contract law. However, the intricacies of individual contracts often necessitate legal expertise for complete understanding and protection. Understanding the implications of warranties is another key aspect of consumer protection. A warranty is a promise or guarantee regarding the quality, performance, or durability of a product or service. Express warranties are explicitly stated, either verbally or in writing, while implied warranties are automatically provided under the law, such as the implied warranty of merchantability, guaranteeing that a product is fit for its ordinary purpose. Understanding the terms and limitations of warranties is crucial in protecting your rights as a consumer. Furthermore, the concept of unconscionability in contract law is also important. A contract is considered unconscionable if its terms are so unfair or one-sided as to be shocking to the conscience. Courts will generally refuse to enforce unconscionable contracts, protecting consumers from exploitative agreements. Understanding these principles provides you with essential tools for challenging unfair or oppressive contractual terms. In conclusion, while the legal landscape of contracts can be intricate, understanding the fundamentals of offer, acceptance, consideration, and breach of contract empowers consumers to engage in financial transactions with confidence. By carefully reviewing contracts before signing, seeking clarification when necessary, and consulting with professionals when dealing with complex agreements, you significantly reduce the risk of financial exploitation and strengthen your ability to resolve disputes effectively. Remember, proactive engagement with these principles is an essential element of robust consumer protection. Vigilance and knowledge are your best defenses against unfair or deceptive contractual practices. Proactive consumerism, informed decision-making, and judicious engagement with legal resources are the cornerstones of a secure and financially stable future.
Like and subscribe for more content.